Good morning, good people. It is beautiful day, May 2022, with me, Aisyah Hadirah, live from Teno Studio. According to a police report that was shared by the victim, the accident itself had taken place along Jalan Sultan Ismail on the 19th April 2022 at around 12:04 a.m. At the time, the victim's name, Azeman, had been driving a red Proton X70 SUV with a female companion and had stopped their car behind the white Ferrari at a traffic intersection when the lights had turned red. However, when the lights turned green, the victim claims that the Ferrari spontaneously reversed and he had already sounded his car horn before the front car continued moving backward until knocking into the front of his Proton and causing a minor accident. Instead of getting down to talk, the Ferrari sped off towards Kampung Baru, so Akil decided to give chase. Due to the high traffic, the Ferrari driver stopped outside a Pro 2 premise at Jalan Raja Abdullah. When Akil confronted the man, the driver denied reversing into Akil's car and started threatening him. The man grabbed Akil's phone and threw it away. The assailant had allegedly choked the victim and punched him in the head to the point that he fell on the ground. He continued to assault Akil while he was lying on the ground before members of the public stepped in to help. According to Akil's tweet, the Ferrari driver also threatened Akil's friend and tried to take away her phone when she wanted to take pictures of his car as evidence. Akil says he sustained injuries to his elbow, left ankle, and body as a result of the incident. In a corroborating report from China Press, a popular live stream host has since come forward to admit that he was the driver of the white Ferrari, which has often been seen featured in the background of his live stream videos. According to the man, Umanse, who is popularly known by his moniker as the Prawn King due to his business in selling fresh seafood online. He claims that he had not backed his Ferrari into the victim's Proton or been involved in a physical altercation with him. To make things clear, we have invited two law students from a public university of IIUM to discuss in details as to what will happen to the parties to prevail justice. So for the first panel, we have Sister Ainn Thuraya with matric number 2113886. Next, we have together with us Sister Adlin Ilyana with matric number of 2113266. So Adlin, do you have in mind any case related to the topic of assault and battery?
Thank you, moderator. So I'm going to talk about the first case, which is Tan Kian Ho and Po Kian Chong, which happened in 2008. So summary for the case is that outside of his coffee shop, the plaintiff, which is the appellant, was assaulted and beaten by the defendant, which is respondent. So according to the plaintiff allegation, he observed a punctured tire on his car parked behind his shop. He had parked his automobile in an area reserved for taxis. So the defendant caused substantial harm to the plaintiff, including an injury to his right eye when he inquired about the puncture. So only when the plaintiff's wife intervened and stopped the defendant had the defendant stop assaulting her. The learned magistrate rejected the claim, and as a result, the plaintiff has filed an appeal. So the judgment of this case is, the first one is on the preponderance of probability of this case of assault and battery had been made out by the plaintiff, even without the evidence of his wife. The fact that the plaintiff had sustained injury during the incident was corroborated by medical evidence, and further, the plaintiff evidence that the injury was caused by the defendant was corroborated by the plaintiff witness 6. The second judgment is that the learned magistrate misconstrued the plaintiff evidence, where the plaintiff said was the defendant had stopped beating him when his wife came in between them. The plaintiff did not say that was the only reason why the defendant stopped attacking him. In any case, whether or not the beating only stopped after the plaintiff's wife intervened was really a non-issue. The real issue was whether the defendant assaulted the plaintiff has caused the injury. The court must not be unduly concerned with the travel or worse, non-issue. The third judgment is that the learned magistrate had not even referred to the medical evidence, where it appears that he has more interested in what was not before him rather than what he had before him. Other than finding that the plaintiff did suffer some injury, the learned magistrate did not make any other finding of fact. So clearly, it was his duty to judicially consider and evaluate all the relevant evidence and make his finding thereon. His failure to do so warrants appellant intervention. So the last judgment is that the plaintiff witness 6 lied to the immigration authority in the past had no relevance to the issue before the learned magistrate. In any case, there was no evidence that the lie had anything to do with her employment with the plaintiff. The evidence should have been disregarded for being irrelevant and whose prejudicial effect outweighed its probative value, and therefore the court allows the appeal.
How about you, Sister Ainn? The floor is all yours.
Yes, moderator, I do have one more case which can relate to this topic. The case is the case of Muhammad Mustaqim bin Jidin and Muhammad Zulfadli bin Razali and others in the years of 2017. In this case, the plaintiff was a private Laskar Udara II in the Royal Malaysian Air Force RMAF stationed at the RMAF base situated at Jalan Airport Lama, Kuching, Sarawak. He pleaded that on 6 September 2014 at about 1:13 am at the Barrack Bujang of Block 6 Provost Pangkalan Udara Kuching, the first defendant, being an agent, employee and authorized representative, had wrongfully assaulted and battered the plaintiff by violently striking and kicking him over his whole body and suffered the serious injury body on the next day. The plaintiff pleaded that from the time he reported for duty at the Kuching base, he was subjected to numerous abuses by the first defendant and has on several occasions alerted the second, third, fourth and fifth defendant of the abuse. The plaintiff therefore claimed the general, special and exemplary damages and loss of future earnings against the first to the fifth defendants. However, he failed to prove that he was entitled to claim damages against the second to the fifth defendants. As for the judgment, in respect of liability under Section 5 and 6 of the Government Proceeding Act 1956, in any claim in tort against the government, the officer of government who has responsible for the alleged tortious act must be made a party and his liability be established before the government can be made liable vicariously as principal. It was submitted that the plaintiff had reported the assault and abuse, but the second to fifth defendants failed to conduct proper investigation and failed to take any necessary steps to prevent the assault and abuse at the base. The plaintiff submitted that the plaintiff has complied with Section 5 and 6 of the Act in suing the second to fifth defendants jointly and severally with the first defendant, and that the second to fifth defendants were vicariously liable for the first defendant tortious act. The judge mentioned that in respect of the plaintiff's claim for damages, I have ruled the plaintiff has to fail to prove his case for vicarious liability against the second to fifth defendants. This assessment of damages is only against the first defendant. Based on the pleadings, the evidence adduced and on a balance of probabilities, the plaintiff has failed to prove liability or vicarious liability against the second to fifth defendants for the assault, battery, or abuse by the first defendant. The plaintiff has also failed to prove negligence against the second to fifth defendants as pleaded. He failed to prove that he was entitled to claim damages against the second to the fifth defendants. Now we come to the decision of the case. The court allowed the appeal and it was held that the first defendant was liable. The plaintiff is awarded general damages of 100,000 ringgit Malaysia for his injuries including pain and suffering and PTSD, RM 4,570 ringgit for special damages and cost of 2,000 ringgit plus allocated against the first defendant.
I myself have prepared a summary of a journal article that I've read that is related to our topic of assault and battery that might be useful for our discussion. The article is titled Intentional Torts, Some Torts on Assault and Battery by F.A. Trindale. This article is about two torts, assault and battery, which together with false imprisonment constitute the action of trespass to the person, which has survived to the present day. Assault and battery are not fashionable or popular torts in the sense that they are not much used to vindicate rights, as is the modern tort of negligence, even when they are capable of being so used. First of all, many of the cases of intentional assault and battery are also crimes, and recent developments in compensating victims of crimes, which have generally made it easier to obtain compensation, are naturally relied upon by the victims of such crimes rather than the civil actions for assault and battery, especially as there is some evidence to suggest that many of those who commit these intentional torts are impecunious and therefore not in a position to pay the damages that may be awarded against them. Secondly, there is, or so it would seem, a certain confusion, perhaps even ignorance, about the ingredients of the intentional thoughts of assault and battery. Quite recently, a Canadian judge expressed the view that the distinction between assault and battery had been blurred, and that when we now speak of an assault, it may include a battery. The requirements of directness, the nature of an intentional act, the kind of contact required for battery, the kind of threat required for assault, the sort of apprehension sufficient for assault, the relevance of the knowledge of the plaintiff and defendant of the assault and battery, and the question of consent are all matters which are not dealt with adequately or with sufficient clarity in the textbooks. The thought of false imprisonment, though one of the three thoughts of trespass to the person, is very different from assault and battery, both in the ingredients of the thought and in the interest which it attempts to protect. It is assumed in this article that the action for trespass to the person is confined to direct intentional acts, even though this writer has argued elsewhere that trespass also lies for direct negligent acts. Thank you. So coming back to our scenario that we have mentioned earlier, do you guys have any legal analysis regarding the legal issues stated?
Of course, we both have discussed on the legal analysis, and for the first and third issue will be discussed by me, while the second and the last issue will be further explained by Sister Ainn. So, for the first legal analysis one, which is whether human's action when he threatened or killed is constituted as assault. So, what is assault? Assault is an intentional and direct act of the defendant that caused the plaintiff reasonable apprehension of the immediate infliction of a force onto his person. So there are three elements that need to be fulfilled, which is the first one is some gesture of preparation to commit battery, also known as mental state of the defendant, where the defendant must have the intention to perform his act. It can be illustrated in the case of Tuberville and Savage, which is the fact of the case is that the defendant laid his hand upon his word and told the plaintiff, if it were not a size time, I will not take those words from you. And it was held that this word negativate the element of intention on the defendant's part to injure the plaintiff, and therefore assault was not established. So the application that I can apply in this case is that it can be seen that Yumansi had the intention to do harm to Akil, where it is because he had more bodily movement by grabbing Akil's phone and throwing away after being confronted by Akil. Different with the case of Tuberville and Savage, this act does mean that the threat would be carried out at any time he wanted to. Thus, this element is fulfilled. So, for the second element is plaintiff feel reasonable apprehension of immediate physical contact by the defendant, where the rule of the case is that the plaintiff must feel reasonable apprehension that a force is being inflicted upon him. Reasonable apprehension can be determined by the objective test, which is if a reasonable man encountered the same circumstances in which the plaintiff was in, he might feel apprehensive that a force would be inflicted upon him. If yes, this element is fulfilled. So, force is being defined as some form of violent contact which will put a reasonable man to be in reasonable fear of attack. So it can be illustrated in the case of R and St. George, where the defendant, which is St. George, got into an argument with the victim, Mr. Durant. During the course of this argument, the defendant took out a gun and pointed it at Mr. Durant. The gun was in fact not loaded. He was in any event prevented from taking further action by the third party. The defendant was prosecuted for assault. So it was held that pointing someone with an unloaded gun constitute an assault, and thus the defendant was found to be guilty of an assault. So, application that can apply to this scenario is that Akil must feel reasonable apprehension or fear that a force will be inflicted upon him. Answering an objective task, that is, would be a reasonable man faced with the same situation that the plaintiff was in, feel apprehensive that a force would be committed upon him. So, looking at Akil's situation, he does feel startled after his being treated by the humancy. This shows that he does feel reasonable fear that a force will be inflicted upon him, which can be seen in the case of R and St. George. So, hence, this element is fulfilled. So, we move on to the last element, which is the defendant has the ability to carry out the threat. So, the rule which is this element is determined by the eyes of reasonable plaintiff, where the objective test is that will a reasonable man who is in this position of the plaintiff feel reasonable fear that there is a threat of immediate force upon himself. So, in other words, if the plaintiff knows that the defendant have the ability to carry out the threat, then yes, this element is fulfilled. Therefore, what must be apprehended is actual physical contact. We can rely to the case of Stephen and Myers, where the defendant made a threatening gesture to the plaintiff by waving a clenched fist against him, but was stopped by a third party before reaching him. So it was held that it was stated that clenched fist was considered as an assault despite the intervention of a third party. Thus, the defendant was found liable for assault. So what can we apply to this scenario is that would the reasonable man believe that the defendant will realize his threat? Referring to the case of Stephen and Meyer, Akil was obviously induced by fear and apprehension of immediate force when Umansi started threatening him and throwing his phone away, as he could easily feel that Umansi had the ability to carry out the threat. Thus, the last element is also fulfilled. So, what can we conclude from this scenario is that Umansi can be found liable under assault as he has fulfilled these three elements.
Now we move to second legal analysis that concern with second legal issue. So the second legal issue is whether Umansi, the Ferrari's driver, can be liable for battery as he choked and punched Akil until he fell on the ground. In order to answer this question, there are four elements that need to be fulfilled. The first element is the intention of the defendant to apply force. Generally, the defendant must have applied the force intentionally, although the general rule is that the intention relates to the direct act of the defendant. In Cole and Turner, the judge stated that the least touching of a person in anger is battery. Referring to the case of Scott and Shepherd 1733, where the fact of this case, a light squib was thrown by the defendant into an open market area. A picked the squib and threw it to B, and B continued to throw it away. The squib hit the plaintiff, whereupon it burst into flames. It was held by the court that the defendant was liable for the tort of trespass to person, although his initial act did not directly affect the plaintiff. According to the court, A and B reacted for their own safety, and so they did not have the required intention to commit the act. And therefore, the first element was fulfilled as Umansi intentionally applied the force as he was very angry before he punched Akil. The second element that needs to be fulfilled is the act was under the defendant control. Generally, it means that defendant acts must be done voluntarily. Referring to the case of Given and Pepper 1695, the defendant was riding a horse when someone hit the horse from behind, causing the horse to bolt. The horse collided with the plaintiff, and it was held that the defendant was not liable as the act of the horse bolting and colliding with the plaintiff was outside the defendant's control. Applying it to our current situation, the second element was fulfilled. It happened when Umansi punched Akil. He had the choice to stop himself from doing that. Umansi not being forced to punch Akil, and therefore his act was done voluntarily. The third element is the contact of application of force occurs. Generally, there will be no battery if there is no contact or application of force with the plaintiff body of clothing. Any physical contact with the body is sufficient to constitute contact. In the case of Wilson and Pringley in 1986, it was held that an intention to injure was not an essential ingredient of an action for trespass to the person, since it was the mere trespass by itself which was the offense, and therefore it was the act rather than an injury which had to be intentional. However, the intentional act to be proven to be hostile touching and hostility could not be equated with ill will or malevolence or governed by obvious intention shown in acts like punching, stabbing, or shooting, or solely by an express intention, although that could be strong evidence. Applying it, the third element was fulfilled, as there was no contact application of force done by Umansi to Akil. Umansi punched Akil several times and caused the injuries. And the last element to answer this question is without plaintiff consent, which means that it is without lawful justification. Generally, one cannot touch another person without his consent or without lawful justification, but there are touchings where a presumed implied consent exists, like tapping a person's shoulder to get his attention or brushing shoulders on a crowded bus. In the case of Nash and Shin, 1953, plaintiff went to a hairdressing salon where the defendant used a tone rinse without first obtaining the plaintiff's consent. The plaintiff developed some skin complications due to adverse reaction to the tone rinse. It was held that the consent given by the plaintiff did not include tone rinse, and in consequence, thus the battery was established. Applying it, the fourth element was fulfilled, as there was no consent given by Akil for Umanse to punch him. There was no lawful justification posed by Umanse. In conclusion, Umanse can be found liable under battery as he has established all these four elements.
For the third legal analysis that we can extract from this scenario is that whether Akil can claim damage for the injuries suffered to his elbow, left ankle and body. So, remedy can be sought by the plaintiff through action in the court. Damages of legal damages is the amount of money paid to the aggrieved party to bring them back to the position in which they were before the tort had occurred. So, they are paid to the plaintiff to help them recover the loss that they have suffered. So, damages are the primary remedy in the course of action for tort. Besides that, special damages has been described in the case of Sang Woon Hong and Kader Imran Shah, which happened in 1981, whereas out-of-pocket expenses capable of pecuniary assessment. These also include medical bill, while general damages on the other hand comprise damage for pain and suffering, loss of immunity and the like which the law implies. So, in this instant case, Akil might claim for special damage to pay for the expenses of his medical bill since he need to treat his injury at the hospital. According to the rule in Tai Ying Tong and Liu Tai, he could claim for full amount of payment if he seek treatment from government hospital and only 1/3 of the medical expenses if he seek treatment from the private hospital. So, besides, general damages was described as simply compensation to the injured party for the purpose of reparation as far as the wrongful act and its consequences are concerned, insofar as money can compensation in the case of Ong Ah Long and Dr. S. Underwood. He can claim damage for the injury itself when he suffered from the injuries to his elbow, left ankle and body. Therefore, Akil may claim for general damage to get compensation with regard to mental injury sustained from Umanse act of committing battery toward him. I think that's all from me. Thank you.
Thank you, Sister Adlin, for the third legal analysis. And now we move to the last legal analysis that concerns with the fourth legal issue, which is whether Umanse can claim under self-defense when he attacked Akil. Basically, self-defense is the most common defense which is used in assault and battery cases. A person may use reasonable force to protect his person or property from attack. The defendant must prove that it was reasonable in the circumstances to defend himself and the force used by him was reasonable. In the case of Croft and Smith in 1705, the clerk of the court sued an attorney for beating off his forefinger in a scuffle. The judge in his judgment stated that in the case of a small assault, a man must not give a violent or unreasonable return. It was no defense for the plaintiff had first run his fingers towards the defendant's eyes. It is possible to defend those with whom one is in a close relationship, such as spouse, children, and employer. Applying the rule above, Umanse's action when he choked and punched Akil is not in reasonable circumstances to defend himself, as he is the first one who started to punch Akil voluntarily. The force used by him can be considered as not reasonable because the action was made voluntarily when he kept on punching Akil until someone in public stepped on into it. Therefore, Umanse cannot claim under self-defense as his action was not in reasonable circumstances to do so.
Thank you so much, dear panels, for the delightful answers. We have now come to an end of the session. I hope the topic of assault and battery will be much clearer to everyone. Thank you for being with us till the end. Have a nice day.